Good evening, everybody. This is Jonathan Ginsberg. It is August 5th, 2026. Hard to believe we are already in August. School here in the Atlanta area started up earlier this week, which is, again, hard to believe that school's back in session, given that it's still 90 degrees out there. I know a lot of places up north, school doesn't start until after Labor Day, but here in the South, it starts right at the end of July, 1st of August. So traffic is again crazy, but again, we are all hopefully healthy and surviving, so that's a good thing. And I welcome everybody to our Wednesday evening live stream. Let's kind of jump right into the questions and comments. Ron Kimbrough from Arlington, Texas says, oh, okay, so he apparently has been following the videos and maybe has talked to Madeline in my office. Madeline is a legal assistant in my office, and he was able to get approved on his own. We take the position that if someone just needs a little bit of advice, if we can give it to them, we'll do it. Sometimes it's just a matter of, this is what you want to say or how to fill out the form. Obviously, I don't stay in business if I'm just offering, free hour-long case consultations, but sometimes it's just a matter of stay the course or wait until you get denied and then call us, and we do that because again, this is a confusing process. That's why I do the live stream, but every once in a while somebody will say, the videos or the live stream help them get approved, and that's cool. And if that happens, leave me a nice review. Go to Ginsberg Law Offices on Google and leave a review, or just go to Avo or any place where you can leave reviews and leave me a nice review. That will be more than enough. Okay, great. Thank you. This is, again, Ron has been referring people, which I really appreciate that. Thank you very much, Ron. And I hope that I'm glad you won. Texas is actually a difficult jurisdiction in many respects because it tends to be a little lower than average approval rates, and the cases take longer to get processed. So that's an achievement to win early in Texas. So congratulations on that. All right. Looks like J.E. in Arizona says, does Palms 2701 TN11 really offer any new or better benefit? And I saw that one coming up, so I looked that up. And let's share the screen. I'll show you what that is. And what he's talking about, Palms, is, let me just share the screen here. Okay. Oh, that's the wrong one. Huh. Oh, no wonder, because I've got the wrong. Well, that's fine. I must have pulled the wrong one up. Okay, so let me go ahead and pull that one up because I was looking at that before. Here we go. Okay. Let me look this one up. Share screen. There we go. Okay. And basically what this is something called make it bigger. There we go. POMS stands for Program Operation Manual System. And basically what it does is it gives instructions to the adjudicators and judges about how to operate the system. It's kind of an operating manual. And so they came out with a revision to the POMS relating to reconsideration in January of this year. And so I believe that J.E.'s question is, did that make any substantive changes? And I will tell you from my experience, no. I'll just show you one thing I saw here. Claimant's rights. The reconsideration provides the claimant a de novo review of the evidence. BS. I look at the denials from both initial and recon, and the denials at recon are most of the time word for word from the denials at initial. So they say another person's looking at it, maybe so, but recon is still the lowest percentage of reversals. There's something called a waterfall chart, which I'm not going to put up, but the waterfall chart shows the approval rates at various stages. I think I've got it in my blog. It's someplace, but anyway, at initial, It's about 36, 38% of initial applications are approved, and those are typically listing level claims, people with terminal cancer, some terrible disease that's going to be life limiting or certainly life altering. In those cases, they do want to get them approved early. So a person with ALS or a person with cancer or a person who's had a leg amputated, those cases get approved early. If you are denied, and usually it's because they didn't see that it was something life limiting, you file this request for reconsideration, which is what this POMS regulation is talking about. That's the first appeal. And at Recon, the approval rate, technically they say, is like 18%. It kind of hovers between 10 and 15 or 18%. It's really pretty low. And basically it goes back to the adjudication office, the state agency office. A different adjudicator looks at it, but of course they have the file from the previous one. And my experience, if anything, they will, give less of the benefit of the doubt to the claimant. So, for example, if the initial, the adjudicator found the claimant was limited to light work, at Recon, a lot of times it says, no, that's not right. It was medium work. So they give them more capacity. So I don't think that there's any real change at all in this regulation. It's just, putting into words what their aspirational goals are. But Recon is and remains a waste of time. A cynic would say that they do this because it delays the process and, of course, it preserves the trust fund, number one. And number two, it encourages people to give up, which, whether that's the case or not, if that's the practical effect, because you get denied at initial, it's 9 or 10 months. You file an appeal, you get denied at Recon, it's another 8, 9, 10 months. Now you've been in the process for a year and a half, 18 to 20 months, and you've been denied twice. And you're just like, this is useless. I'm not going to waste my time anymore. Don't bother requesting a hearing. That's the wrong approach. You definitely want to continue appealing, but it does have the habit of chilling people from filing an appeal. So don't let that happen to you. Recon and initial denials don't mean anything. And at the hearing, you do get what they call de novo or a new review. So, this, in my opinion, this is just, words on paper. It doesn't mean a darn thing. So I wouldn't, it doesn't give you any benefit at all, so from what I can see. How long does it take the Recon to be assigned to an adjudicator? Yeah, and he called the local, or he or she called the local DDS, which is the state agency. And they said it takes 280 to 300 days to be assigned. And what that means is that your case, you filed your initial case, it was denied. You filed your Recon appeal, and what they're saying to JE is that this case is going to be in limbo for 280 to 300 days, 9 months, 10 months before it's even assigned to an adjudicator. We're not talking about having an adjudicator look at it. It's just going to be what they call staging for 9 or 10 months, and then it's going to be reviewed, which will take another 5 or 6 months. That seems a little bit long to me, but that does sound like more of an adjudication timeline. The problem is they're so short-staffed that these cases are sitting there for months or years. I have cases that are sitting there for years, and the only way to really get it moving, and I would tell you, JE, to do this, contact your U.S. Senator. I think it's Senator Kelly is one of the ones in Arizona, if I'm not mistaken. Is contact his office or the other senator's office and say, look, I filed my reconsideration. I would wait till it's been pending for about 4 or 5 months, because before that, they're not going to really take any action. But once it's been pending for 4 or 5 months, say, file my recon. I've already been waiting a year, however long you've been waiting. It's been 5 months on recon. I called and they said it was going to be 300 days before they even assigned an adjudicator. That is unacceptable. This is causing me a great deal of financial and emotional stress. Will you write a congressional inquiry to find out what's going on, get this thing moving? And what will happen is, lo and behold, your case will be assigned to an adjudicator. That's the only thing that seems to work, is to have a congressperson, ideally a U.S. Senator's office, call. And every U.S. Senator has staff people devoted to Social Security, 2 or 3 people that's all they do is Social Security. And if you go to any website for a senator, it'll say, Senator Kelly, you want help about dealing with a federal agency, and you click further, it's Social Security, or you may have to explain what your issue is. But make it clear you've been already waiting for X number of days or years or whatever, and you've been waiting on the appeal for 5 or 6 months, and they're telling you it's going to be 300 days, and this is causing extreme hardship. Please find out and use the word congressional inquiry, and that will move things along. So, it's a broken system. They don't have enough staff. They are trying to put more AI. They're trying to do more things electronically, but it's a long, slow process and probably will not be fully implemented for a while. I think the other issue with the computerization, Commissioner Bisignano, that's his real focus, is to bring it into the 21st century and use technology. And of course, with the technology, we know if you've ever called like a credit card company, you get the AI answers where it'll talk to you and it'll ask you questions and it responds to you, and it's getting more lifelike, but you can tell it's a machine. The problem is that, number one, there are people out there who are not particularly computer literate, and who don't understand how to interact with those type of things. They don't know how to use the computer to file their appeals and things like that. And Social Security is sort of forcing everybody to use more online systems. And when you call to go through the voicemail tree, and if you don't speak clearly because maybe you've got a medical issue that doesn't help you speak clearly, it's going to be a problem. So, you're dealing with a community of people that are disabled by definition. And again, some disabilities are physical, but you have a lot of people who, especially people in their 50s or 60s, who may be, have limited technical skills, but you're asking them and demanding that they play in this system, as opposed to talking to a human being. So I think it's going to get worse before it gets better, unfortunately. Now, again, at the end of the day, will we all be better off if more of this can be done electronically? Very possibly. There's a lot of stuff that Social Security does that doesn't really need a human being. But, for a lot of people, they want to talk to a person and they don't feel comfortable, interacting with a computer screen, or a computer voice. So, this is going to be an ongoing issue. But I think, going for a congressional inquiry would be my advice. And Ron says, this is echoes what I said before, keep trying, don't give up. He got approved at Recon, which is very difficult. Use my videos, use Walter Knott's videos, use Stephanie Joy's videos. There's a lot of Michael Leiner. There's a lot of good people out there who've done videos, and you've got a lot of free information out there, and make it your job, as it were, to learn as much as you can about the process so that you're an educated claimant. This is a confusing process. It can be maddening because it takes so long, but the more you know about it, the better you're going to go, better it's going to go for you. As Ron is an example of that. Okay. Haq Assad, one of our regulars. Yes, all is well. Thank you. You're very welcome. How early, Haq asks, do ALJs and staff usually review a case prior to a hearing date? Do staff attorneys do a review and provide a top sheet for the ALJ? I don't know. Honestly, that would be a question. At least Enton might be able to answer that. She used to work as a staff attorney. I will tell you that judges have told me in the past that they will look at a case anywhere from 2 weeks to 1 week before, typically the weekend before. A lot of judges will do it on the weekend where they'll get their file, they'll look through it the weekend before the hearing or maybe 2 weeks before the hearing. If they're lucky, they have a staff attorney that will do kind of a worksheet for them. I suspect they're going to try to use more AI. I will tell you that judges, a lot of times, they will have notes, and so I'm guessing that somebody's doing that for them. Maybe they do it themselves. I don't see how they have the time for it. But I would tell you that probably once the case is assigned to a judge, I would assume it's not going to be any more than 2 weeks ahead of time, probably a week ahead of time, because realize that they've got, if they're hearing 15 or 20 cases a week, which, if they're doing 2 or 3 days a week, they're hearing cases, if you reviewed a case on this coming Sunday and it was scheduled for the 1st of September, you're not going to remember as much. And so I think a lot of them may do a cursory review a couple weeks out, and then the week before they'll look at it again. I'll also tell you that judges have said to me that if the case has $3,500 pages of records, a lot of VA records, they won't read it all. They will scan it, they will look at it, and they will try to look for, they'll probably do the same thing I do, which is, or I used to do, which was put it in a PDF reader and search for phrases like MRIs and things like that. I think they do rely on briefs. I mean, I'm trying to get my briefs in, if I can, 3 weeks ahead. Certainly no less than a week ahead, but I try to get it in a couple weeks or 3 weeks ahead. And I've had, in the last month or so, I've had 2 cases approved on the record, no hearing at all. And I've had a couple of cases where I look at the decision and the wording is lifted almost directly from my brief. So I think they do appreciate a brief that is, well done, that is accurate. You don't have to do them, but I think it does help a little bit. Now I've had also staff attorneys tell me that judges, they don't necessarily want to look at a brief. So who knows? But my experience has been that a brief is usually a good thing. At the very least, for me, it forces me to really solidify in my mind what my argument is. And now with AI tools, getting briefs done is a lot easier, because some of the sort of the preliminary work, or the just the facts, that can be stuck in there, and you can already sort of halfway there where you can get into the substance. But anyway, I do think that to answer Hawk's question, I would assume about 2 weeks ahead, maybe as little as 1 week ahead. Kevin Johnson says, "Good evening, Grandpa Panda." Hello, yes. Hey, Kevin. I actually had my grandson, Wednesdays, my wife and I take our grandchildren. Today she took my granddaughter to swimming, had a music class, 2.5-year-old music class in swimming, and I had my grandson, who's like 4 months, starting to scoot around, not quite crawling yet, but we hung out, and he doesn't say very much, but he looks at me and he smiles, so that's a good thing, I guess. I don't scare him, but we hung out and just had a couple of bottles and took a couple of naps, and we played on the ground, and that's that was kind of cool. So I'm very fortunate I have a chance to hang with the grandchildren pretty much every week, or actually almost every day, but every Wednesday I get them all day long. Put a VE witness. I've had a VE witness on. I will try to get another one. There are a couple that I know that I'm friendly with, and I will be happy to try to get somebody on. I had one on, and I don't remember if he wanted me. I'm not going to say his name because I'm not sure if he wanted me to use his name, because he's still an active VE. But there's a couple others that I'm friendly with, and I will see if I can't get somebody on who would give us their intake on, or their insight on what VE testimony is all about. In fact, interesting, I just got an email from a legal aid person in California who asked me, is there a course I'm aware of about how to cross-examine VEs and how to, go after the job numbers and qualifications. And I'll tell you exactly what I told her. I said, look, there are 2 schools of thought about how to deal with VEs. One school of thought, which is what I kind of adhere to, is that the VEs are only answering questions for the judge. And if the judge wants to give, very minimal limitations, the person would be off task for 2% of the day, would miss 1 day every year, and has, a level of pain that allows for frequent handling and fingering, kneeling and stooping, can stand for 6 hours a day, walk, stand and walk for 6 hours a day. Basically a very mild limitation. The VE is going to say they could do past work, or there are other jobs they could do. If the judge's question is this person would be off task, that's the term they use, for 15% of the day, they're likely to miss 2 or more days of work per month. They are limited. There's no climbing ladders, ropes, and scaffolds, no kneeling, crouching, crawling, or stooping. They are limited to occasional handling and fingering. And because of pain, they're limited to simple entry-level 1 or 2-step jobs. The VE is going to say, based on that hypothetical, there are no jobs I can identify. That has nothing to do with the VE. It's just the question the judges are asking. And realize the hearings last 45 minutes. So my experience is that a judge is not really going to be all that patient about, questioning the VE on qualifications. When's the last time you did placement, and what sources do you use? There's a second school of thought that many attorneys that I respect greatly adhere to, and that is go after the VE, go after them hard. There's an attorney named Larry Rolfing, who's sort of the biggest proponent of this. He's got I think it's called the California Social Security Attorney Blog, something like that. There's an attorney named George Piamonti I think he's in North Carolina or Tennessee. He writes a column every month for the NOSCR Bulletin where he talks about questioning the VE. And certainly Rolfing's approach is that every VE is full of crap, and you can challenge every single one of them. And perhaps you can. The problem is, in my view, let's say that you find that the VE, cannot explain accurately where their job numbers come from, and I'll explain what I mean by that. One of the questions is that a judge is trying to find out is, do jobs exist in significant number in the economy, based on the hypothetical the judge is given. So if there are 15 jobs nationwide for, let's say, elevator operator, that is not sufficient to deny a claim because there's just not enough jobs out there to be significant. I think I read someplace it's got to be maybe 10 or 20,000 jobs nationally, something like that. So the reality is nobody knows how many jobs there are out there. Job that I had, and I'll give you this scenario in a second, but a job in a case earlier this week was an information clerk, which is I think it's a light, semi-skilled job. And the testimony, there's 100,000 of these jobs, whatever. The reality is nobody really knows. I mean, there are, the Social Security used for many years something called the Dictionary of Occupational Titles to describe what functions were in the job, and then there's, other resources about how many jobs exist. Now there's this sort of smorgasbord of resources, or something called the Selected Occupational Characteristics, or SOC codes, which don't line up with the DOT codes. Then you've got Job Browser Pro or OccuBrowser, all these different resources that will tell you how many jobs exist. The reality is nobody really knows. And Social Security knows that nobody really knows. But they work under the fiction that we've got to have some information out there for us to rely on to say, talk about these different jobs. Let me just take a look. SSA ruling about vocational test sources. Okay, so there was so the bottom line is that for years, people would appeal decisions on the grounds that the VE testimony was an error. And sometimes if the VE testimony was clearly incorrect, you could make some headway with some federal court judges that the VE did not properly explain where they came up with their numbers. And people have been knocking at that door for years. And eventually, a case, I must have gotten to a circuit court, I don't think the Supreme Court, but a circuit court, where basically a circuit court, which is the level over the district court. So now we're getting into, there's I think 13, 14 circuits in the country. So now we're right below the Supreme Court, and we have a judge at one of these circuit courts say, Social Security, we've been living under this fiction long enough, using the Dictionary of Occupational Titles, which was last updated in 1991, and some of the jobs in the 1970s. You got to do better than that. So they issued a ruling, and the Social Security incorporated that ruling incorporated that finding from the district court or the circuit court into a ruling called SSR, Social Security ruling 24. Let's see, I think it's 2413P maybe. Let's see, I should know this, but I don't know if the. All right. Anyway, it's ruling. I want to tell you. I want to give you the correct information here. In fact, I had this out, and for some reason it disappeared on me. All right, give me 1 second here, and I will tell you what the ruling number is. it's 24, 3P, SS ruling, or SSR 24 3P. What that does is it says that any vocational testimony, the Social Security or a judge has to inquire about the sources that were used by the vocational witness. So what's going on now at every hearing is a judge will say to the vocational witness, what sources did you use to come up with your information? And they'll say, well, I looked at the Dictionary of Occupational Titles, I looked at the selected characteristics of occupations, I looked at Job Browser Pro, I looked at OccuBrowser, I looked at all these things, in my own experience. The judge will say, thank you very much. Counselor, do you wish to cross-examine on that? And yeah, could I do that? Could I say, well, can you explain to me Job Browser Pro's, proprietary methodology? And of course they can't because it's proprietary. Or could you tell me when the last time you placed a information clerk was? But at the end of the day, the judges are going to say, Social Security has said that as long as they've made a good faith effort to explain where their sources and they're using generally accepted sources, we're going to accept that. Would a district court at some point say that's not good enough? Maybe. But you know what? You're at that point. You're appealing, and you keep. What ends up happening is, let's say that you're successful in getting a remand. It goes back to the judge, who's going to find another reason to deny the case. So to me, it's a big waste of time. Now that being said, there are cases where a vocational witness will, I think, make a legitimate mistake. I'll give you an example of that. I had a hearing this week, and my client had been a postal worker for 30-something years. That's all she did. And so she was over 60, and the judge limited her light work. And so under the grid rules, if a person limited to light work and they can't return to their past work, they're not disabled if they could make if they could use their skills, transferable skills, into another job. But at age 60, with light work, there's got to be what they call a minimal vocational adjustment. And basically what that means is that they could go in at day one and they could start working. They wouldn't have to learn anything new. So I asked the vocational witness, I said, okay, this person has been at the Postal Service for 35 years, and the vocational witness had given this job as information clerk and said that the skills were customer service. Okay. So I said, well, person has worked with the government in the post office for 35 years. The post office has presumably their own, internal computer system. They have their own methodology, their own way to do things. And now you're telling me that this person can go be an information clerk in some other completely different field in private industry and learn with minimal vocational adjustment, meaning they're ready to go on day one or two, a completely new computer system, completely new methodology, completely new interaction with coworkers, completely different focus and everything. Well, yeah, like, come on. I said, really? I said, so your testimony is that going from a government service job for 35 years to a private industry job in a completely different industry is a minimal vocational adjustment. Okay, he wants to say that, that's fine. If the judge denies the case on that basis, I got grounds for appeal. That is clearly not the case. And I went and looked up, and minimal vocational adjustment means, basic familiarity with the processes and systems of the new job. Well, if I went from a law job doing Social Security disability to a law job doing tax work, which I've never done, presumably there would be a lot of learning to do. Now I realize law is a skilled occupation, but nevertheless, I'm educated as a lawyer. I have skills, litigating cases. I've got skills doing legal research. And those skills would transfer to being a tax lawyer or being an immigration lawyer, but there would be probably a 2-year learning curve. And in a semi-skilled job, there may be 6 months of a learning curve. In fact, almost by definition, any job that is semi-skilled, I think, is a 6-month minimal learning curve. The point is, the vocational witness's testimony was ridiculous. Unfortunately, this vocational witness seemed like a really nice guy, totally unprepared. He wasn't ready for this. He didn't know how to answer it. And, I would ask him a question, he would kind of answer it to agree with my point, then the judge would ask him and he'd kind of backtrack. I think the judge is going to prove my client's case. I think I've been before this judge, and she tends to, kind of go back and forth that she'll approve it. But that's just an example where I had to go after the VE because his testimony was ridiculous. So there are times when you've got to know when to do that. But I'd say most of the time, going after the VE is counterproductive. It just gets the judge upset with you. It takes a lot of time. I've had judges say to me, we need to schedule a supplemental hearing, which is the last thing they want to do. And like I said, there are times when you have to do it. And certainly there's a methodology to go after a VE by asking about how many jobs have this person has placed in this field, or when's the last time they did a placement. Those are legitimate questions because some VEs come out of academia and they haven't placed a person in 15 years. And obviously things have changed a lot in the job market. So in fact, in this case, when I was telling you about, I had a job, I guess I guess it was for it was a postal service job placement offer out there, and it talked about that you had to lift 70 pounds. So one of my questions was, well, here's a job placement offer from the Postal Service saying that they've got to lift 70 pounds. So isn't it true that a Postal Service employee at a window has to be able to lift 70 pounds? And first he was like, no, it's only have to lift 50 pounds or 25 pounds rather, 20 pounds, I'm sorry, light job. And then, well, somewhere between light and medium. Say, well, 70 pounds is, that's even could be even more than medium. So again, sometimes you have to let it lay and just use that on appeal. But that's just an example of where he did look up to see the Postal Service has job placement offers out there on all kind of job boards and things like that. And you can see what they require. They require 70 pounds. He didn't seem to know that. Again, not ragging on the guy. He just wasn't very well prepared. Maybe he does a great job in other cases. I don't know. Again, it seemed like a very nice guy. But that's an example where I felt like I had to be a little more in depth about questioning. The judge didn't really seem to mind it. But I think overall, if you take the attitude, at least from my perspective as an attorney, you're just going to aggressively go after and try to rip the VE apart every single time. I think you're going to develop a reputation that's not particularly good. So long answer to a short question, but that's my take on it. Okay. Haq Assad says attorneys and reps usually take cases based on approval viability, correct, and gripe about staff expenses. Don't they have to pay staff regardless of whether they have a case or not? Yes, you have to pay your staff, but Haq, I would ask you, do you want to work for free? So if 10 people came to me and they were 35 years old with mildly bulging discs and non-insulin dependent diabetes and a broken pinky, okay, I happen to know those cases aren't going anywhere. Would you want me to take all those 10 cases just so I can say I took the cases? No. So, we get paid on a contingency. Does that mean that every case I take is a slam dunk? No. I will take more challenging cases. But in general, if I don't see a path forward, if I don't see that the case is viable, the fact that I'm paying my staff, I'd rather pay them to work in cases that are viable. I'm not going to take on cases that I think have, not that I don't believe the person, and realize there may be situations where I really do believe the person is disabled, but I know from the impairment they've got or their age or the type of medical they've got, they don't stand a snowball's chance in hell of winning, except unless there's a miracle. So no, I'm not going to take those cases. I just can't. The margins on these cases are not that great. I'm not complaining this is the area I got into, but our fees are capped, and you don't get paid if you don't win. And so no, I'm not going to take a case that I don't see any path forward, nor will I apologize for that. So again, no disrespect to you, Hawk, but no, I'm not taking a case if I don't think that it's got a path forward. I don't gripe about my staff expenses. I value my staff. They do a really, really good job, and I'm happy to pay them a fair wage. But I'm not going to pay them to work on cases where I don't think we have a chance at winning. So that's how I'd answer it. Dolphin, hello from California. If you could have SSDI applicant just 3 pieces of advice before they file, what would it be? Okay, so I'd probably give you more than that. Number 1 is be prepared to wait. It's going to take a long time. Best case scenario, it might be 8 or 9 months you get an approval. but more realistically, it's going to be 2 to 3 years before you see the first dime. That's number one. So be prepared to wait and arrange to have a place to live and have, food coming in, your utilities paid, because it's going to be a long time before you see any money, and prepare your family accordingly. So that would be one thing. Second thing is you got to go to the doctor. Social Security assumes if you're not getting medical treatment, there's nothing wrong with you. Is that fair? No, because many times people can't go to the doctor because they have no insurance. They can't afford it. As far as Social Security is concerned, you're not going to the doctor, nothing wrong with you. You got to find a way to get to the doctor, even if it means once or twice a year. Save up, figure out a way to do that. That would be, it's just the reality of it. Third is your attitude needs to be of a fighter. You never go into these cases saying, I know I'm disabled, pay me. You go with the idea, I hate the idea of filing for disability. I worked my whole life. I don't want to do this. I much prefer to be working. I get me social interaction. It was healthier for me, made money. Try to work. An unsuccessful work attempt, I think, is very good evidence. So go in with the idea of you're an absolute fighter. I think I'll give you a fourth one is if your doctor, gives you directions, stop smoking, lose weight, do those things. If a doctor offers treatment protocol, medications, or even surgery, you don't always have to do surgery or take medications that you're concerned about, but consider it. And if you're not going to take medications, you don't want opioids, for example, or you don't want to go through surgery, explain the reason why. And I'll give you one more, last one, which is kind of a don't, and that is, any whiff of drug-seeking behavior or secondary gain, malingering, that will kill your case. So, do not play games with going to different pain doctors to get medications, or, don't give the doctor any reason to think that you are faking it or not being completely truthful. Do everything you can to get better. The focus would be, I would almost tell you to go this far. The focus should be, I'm filing disability because I have no other choice at this point. Realize once you're out for a year, you can make it a closed period. So really the focus really should be, if you're going to be out for a year. But the goal would be, I'd rather be going back to work. If I could get a miracle pill or a miracle procedure where I'm able to go back to work, I'll gladly dump this disability case because I'd much rather be working. That's the approach you got to take. So those are just some ideas that I would tell you if you're starting the process. It's a lot of it's attitude, it's going to the doctor, it's being prepared to wait. And those are the things I would tell you to somebody who's starting out. 55 and older, the ones getting SSDI now, they're not paying anymore. Money is tight now. Well, I would certainly say that, and I'm not seeing statistics, and they may exist or they may not, that anybody over 55, the chances of getting an approval are greater. Not everyone. I've had a couple of people over 55 denied, but by and large, if you're over 55, you have a real advantage. You have the grid rules, which really benefit you, because under the grid rule at age 55, even if you could do light work is defined as standing and walking 6 hours a day, lifting 20 pounds on occasion, assuming no transferable skills, which will be eroded by pain or other non-exertional limitations, you are disabled. So you may have the ability to do sit down or even light work, but you're still disabled under the grid rules. So it's a huge advantage. I've had judges say to me, we all know that Social Security has a bias in favor of people over 55. They assume that when you're over 55, and I fall in that category now, that it would be really hard to get retrained. It would be hard to find a job. I've had clients. I was talking to a client at pre-hearing the other day, and he's like, he actually came out of work because of some medical issues, had a period of time, like a year and a half, where he couldn't work, kind of working on his health, as he put it. Then he got a job, and he's back at work. So we're going for a closed period, which is great. Judges like closed periods, by the way. And he said to me, he goes, when I was looking for a job, he said, I didn't get past the interview stage half the time. Most of the time, he goes, they see a guy who's 57 or 58 years old with some chronic health issues. They don't want to look at me. They'd much rather hire a 35-year-old who's healthy. And that's just the reality. I mean, you may call it ageism, you can call it whatever you want, but that's the reality. Employers, some employers feel like, well, why should I hire somebody who's 58? They're probably going to retire in a couple of years, and I've gone through all the effort training them. So yeah, it's hard to find a job, and Social Security does realize that. Again, that regulation I talked about, minimum vocational adjustment, does reflect that. Although again, not to the degree I think it should, because I think there's a little bit of a disconnect that Social Security assumes that a 53-year-old or a 57-year-old would be able to find a job as easily as a 50-year-old or 48-year-old or 35-year-old. And they do agree that they do acknowledge there's some limitation, but I think the gap is bigger than Social Security recognizes. So anyway, Kevin's point is 55 and older are the ones getting SSD. They're not paying anymore. Money is tight. I guess what you're saying is that, people, and of course, when you're getting disability, you're not paying into the system anymore anyway. So if anything, I mean, if you're looking at this purely from a fiscal point of view, a financial point of view, when you approve older workers, that actually keeps the system more solvent because that's fewer people on disability, and you're getting closer to the age where they transition to retirement Social Security, which theoretically is a different trust fund. Actually, I read the other day where the disability trust fund, which is basically IOUs, is actually quite solvent, not a problem at all. But Social Security as a whole, and they put them all together because the retirement fund was mismanaged or because the actuary tables were not properly evaluated, you have a lot of people living a lot longer than they expected. That's the one that's running out of money, but they combine them together. But if you broke them out, the money being set aside, which is not being set aside, but theoretically set aside on paper for disability is quite solvent. But they combine the two together. So that's where, we're going to find some interesting political battles coming up. But, 55 and older are getting approved, but that's, I think, realistic, and that's probably an appropriate, certainly I wish younger people are getting approved if they have limitations, but older people, yeah, they there's a lot of reasons in addition to their medical problems that would make them less likely to be able to get reemployed. Chloe says, good evening. Hello, Chloe. Cynthia, we have a hearing date in your case. You may know that already, you probably got it. But I was looking at this, and it is in November, early November. And what you may not know is we got a judge with a very, very high approval rate. I was in front of this judge a couple weeks ago. Very reasonable, very smart. We got a great judge. We got a high approval rate. You got a hearing coming up in November, so you're in good shape. I'm looking forward to getting your case won. Kathy, how are you doing, Kathy? Patrick's been here before. Good evening to you. Congratulations to Ron, absolutely. Kathy says, great, okay, you got a notice of attorney advisor decision fully favorable. What that means is that judges will have these staff attorneys like what Elise did, Elise Hinton, who's been in my live stream before. They're called attorney advisors, and they will look at a file and they'll say there's enough here to go ahead and approve it without the need for a hearing. And so in Kathy's case, they obviously did that, which is great. That is really great. Okay. DASBOF, DASBOF. I'm sure there's rationale behind some of these names, but I don't know. DASBO, I don't know what this means, but okay. If you have a dire need for foreclosure situation in your home, what does SSA do? Does it really help? Dire need is a term that Social Security has in its regulations that says that a person facing imminent homelessness or food insecurity or can't pay utilities or buy clothing for their dependents, that is quote a dire need situation. That case needs to be moved to the front of the line. And years ago, you would submit a dire need letter in those situations and they would move to the front of the line. The problem is people found out about it and everybody uses dire need, so it has no meaning anymore. And they're so backlogged that even if you got to the front of the line, it could be 6, 8, 10 months before you got to a hearing. I think a congressional inquiry is a better way to go, because dire need means somebody at Social Security's got to look at it, and you've got to send them in foreclosure notices, and you've got to send them all. You're asking them to look at stuff as opposed to getting a letter from a U.S. senator saying, Social Security, I got an unhappy constituent, deal with it. They will deal with it. So in theory, somebody at the either the hearing office or the field office will look at it and say, yes, it's dire need to put it at the front of the line, but it's not going to really help you very much, I don't think. So I think a congressional increase is a better thing to do just because dire need's been overused, unfortunately. And realize some places, like in Georgia, you can be foreclosed in less than 2 months. So if somebody called me and they're in Georgia and they got a foreclosure, it's going to be in a notice, it's going to be within 2 months. Getting a hearing in 6 months or 8 months is not going to help them. You're not going to get a hearing in 2 months. I mean, so I think that, I would almost tell you that rather than waiting until you get a foreclosure notice or you're on the street or your car's repossessed, contact your senator saying, bad stuff's about to come down, I need a congressional inquiry. Das is 60 years old with past medium job, 11th grade education, just getting in the third stage, medical stage. Again, I'm not sure when you mean that, if you mean in the request for hearing or the initial application, but I would certainly tell you, look at the grid rules, go to gridrules.net. Past work is medium. You can't do that anymore. 11th grade education, limited education. If you've got a physical impairment, I think the grid rules would very likely apply. So look at the light and the sedentary grids and see if one of those applies. And when you communicate with Social Security, say, in fact, let's look up the grids and let's take a look at those so we can look at it in real time together. All right. Here are the grid rules. This is my grid rule website, so you can see it here. So you see I've got, let's start with the light grid. And basically what this says is if you're limited to light work, standing and walking 6 hours, lifting 20 pounds on occasion, okay, you are 55 plus, okay? You have less than a high school education. If you look here and you have less than a high school education, 55 plus, and you have, you didn't say what kind of job you have, but if it's skilled or semi-skilled, but it's not transferable because of pain, again, it's got to be a physical limitation, you are disabled. If you don't have an education, which you don't, if your past worker is unskilled and you have less than a high school education, an unskilled past worker, you're disabled. So the grid rule at 202.02 or 202.04 very likely would win your case. So I think when you communicate with Social Security, say, look at grid rule 202.04 or 202.02, and there you go. Or if you're limited to sedentary work, same sort of thing here, limited or less, unskilled or not transferable, 201.01 and 201.02, you win your case. 201.04, you win your case. So you can see the grid rules really help you. And then because and I'm not going to get into the POMS regulation, but there's a POMS regulation that says that minimal vocational adjustment if you're limited to sedentary light and 60 years old. So it makes it even harder for Social Security to find you a job. You're set up to win. It's just a matter of you got to let them know what theory to work under. But that's what I would, certainly the minimum I would say, look at the grids at sedentary 201.01 or 02, look at the grids at light, which would be 202.02 or 202.04. I think you got a really good shot at winning on that basis. Okay. Now, it doesn't apply if you've got mental health issues. It's got to be physical. But assuming it's physical, that would be how it would go. Okay. Patrick says the same thing that Ron said. Do not quit. Absolutely do not quit. That is correct. Okay. Anita Rollins has a hearing tomorrow morning. I have a plate in my neck, C4-5, which is the cervical spine. Now, herniated above and below is stenosis. That's called associated segment disease, when you have a herniated disc, and then because it puts more stress on the disc below and above, that typically causes problems there too. Flattening of the cord, which means the cord is being impinged, that may cause radiculopathy, numbness in your hands and your shoulders if it's in the cervical spine. So you've got objective evidence, assuming there's MRIs that show that. You don't say how old you are, but assuming you're 50 or older, you've got a grid rule argument for sure, just like we talked about just a second ago. And if you're under 50, I think you've got an objectively determinable problem. And I think the combined effect of limited movement, probably trouble reaching overhead, possibly problems with self-care, getting dressed, putting shoes on, bathing, certainly turning your head side to side or up and down would be a problem. You may be on pain medications that make it hard to focus and concentrate. So I would argue the grid rule, certainly if you're over 50, and if you're not over 50, I would say the combined effect of my exertional, which is the physical part based on your neck issue, and your non-exertional impairments, which is the pain, medication side effects, and anything else going on, would leave me without the capacity to be reliable at any type of job. That's the argument. But I think you want to go in, depending on your age, with I'm going to argue functional capacity. My functional capacity is less than sedentary. I couldn't get through an 8-hour day, even at a simple sit-down job, because of symptoms, the need to rest during the day, medication side effects, focus and concentration issues, as well as the physical limitations. That's a functional capacity argument. Your capacity to function has been so eroded by your medical issues, you would not be reliable at any type of job at all. And again, over 50, you got the grid rules. So I think you have a pretty good argument there. You should be in pretty good shape. And again, if you're under 50, it'll be a little more difficult, but not impossible. Okay, Patrick says, good luck, Anita Rollins, very much. And Dasboff has severe degenerative disc disease, lots of imaging, and that's good. And that, again, I think that you've got what you told me before, that, again, you're the one with the dire need. You're 60, past work is medium, severe degenerative disc disease, which, be careful about that, because degenerative disc disease is basically osteoarthritis, and we all get it. But if, again, it's severe, you've got a lot of imaging, that's going to take you out of medium work, so no past work, and now you're in light work or sedentary work, you got the grid rules. So you got a good argument there, I think, in general, assuming that the radiology reports say what you say they are. Okay, this is an interesting question. If new medical records become available after the evidence deadline, what options does a claimant have? And what she means by the evidence deadline is that when you get ready for your hearing, you are required to submit all evidence within 5 business days or 7 calendar days, or 8, depending if there's a federal holiday in there, before the hearing. And otherwise, and if you don't have it all in, you have to submit what is called a 5-day letter, where basically you say, dear Judge so-and-so, we are still waiting records from XYZ orthopedic clinic. We've requested them 3 times. We've not gotten them. Please keep the record open for weeks for us to get them, or please issue a subpoena for us to get them. Now, what Chloe's asking is, what if records become available after the deadline, during that, so it's more than 5 business days, it's within that 5 business days. And I'll put it in my context. I'm the lawyer. Okay, my client never mentioned that she had gone to neurosurgeon John Smith. She calls me in a panic 3 days before the hearing. Jonathan, I forgot about Dr. Smith. Here's my portal information. Can you get the records in? And so what I would do in that situation would be I'd get the records, I'd submit them, and I would write a letter. And I would basically say my client did not remember, and part of it is because she's on narcotic pain medication, she's in terrible pain. She just advised us of this doctor. Here are the records. We're prepared to postpone the hearing if Your Honor would like, or we're prepared to explain what these are at the hearing. The judge, unfortunately, is under no obligation to do any of that. He could say, sorry, it's within 5 days, and we're not going to give you that leeway. Most judges are not going to do that. My experience has been there are a few that want to draw a line in the sand, and they're going to say, well, it's not within 5 days. They would certainly question me. When did you know about it? What did you do? And again, I'm in a difficult situation because I don't want to throw my client under the bus and say, well, they just told me. But if that's the truth, my client just didn't remember, couldn't remember the name, or thought that, the records were already in there, whatever it may be. The judge has the, could certainly leave the record open, or say, well, it's going to delay the decision. There are some judges who will like, tough, that's what the rules are. I don't think that's really appealable. Again, I think, if the judge denied the case and those records that were submitted late were really important, I can make an argument to the appeals council that, my client's reasons for not providing them were a function of, him or her not knowing what to do or forgetting or being under the influence of medications or having some other reason there. And realize that in Social Security, if you are filing, let's say, a late filing, one of the reasons you might ask for good cause for a late filing of an appeal is that you didn't understand what you had to do or you couldn't do it because of medications or whatever. So, there is a notion in Social Security that some people are going to have problems remembering what to do and do it on time. So, I could appeal it on that grounds. Whether the appeals council or district court would do anything with it, I don't know. Best thing is not to get in that situation, but you can certainly make an argument as to why, but better have a darn good explanation. All right, Anita's got 6 herniated bulging discs with mild stenosis. And here's an example of, and again, I think Anita, you still have a pretty good case based on what you told me before. But this is an example of, I've said to you many times, said to all of you many times, a diagnosis does not win a case. Here, Anita has 6 herniated or bulging discs. That's your diagnosis. But what did she say? Mild stenosis. Stenosis is kind of a, narrowing of the spinal canal. So having herniated discs with mild stenosis is going to minimize to some degree the functional implication of that. So what I would want to know is, what are the functional issues arising from the herniated and bulging discs? Is it pain? Is it numbness? Maybe it's something else other than stenosis. Maybe there's nerve root impingement. Maybe there's, something else. But, mild stenosis is not a good phrase, because that means that it's, that the spinal cord, the space in the vertebrae are not closing. So you may have a bulging or herniated disc, but, is that really going to, is it logically going to cause all kind of problems? Now, herniated disc, a lot of times you have the disc pressing on the nerve. That could cause a problem in addition, outside of in addition to stenosis. But this is an example where, a radiology report talks about mild this and mild that. That's not good for a disability case, although, again, I think in your case, you should be fine. Big Ta had a hand-thumb strength test done by an OT. Percentage was 79%, which looked up as severe disability. Well, certainly it's an objective test, and I haven't looked up to see what that means. But what you want to translate that to is, that you have trouble gripping things, or you have trouble lifting more than X number of pounds. And part of that OT analysis should give you a lifting limit or grip problems. So you want to turn into very practical terms. What does that mean in terms of your functioning? And so, again, 79% strength test, that's just a number. What does that mean? That's what you really need to explain what that means. Hopefully the OT can help you explain what that means, but that is the question. What is the practical implication of that diagnosis or that test result? Because just saying I got 79% impairment or 79% functionality, that doesn't mean anything if it doesn't translate it into vocational terms. Jose, wait, okay, and Jose or Joe had appealed a case and I guess submitted a brief to, in favor of his position, and the Social Security Administration gets the U.S. Attorney to respond, and basically he's going to, he's in litigation now in district court. He submitted a brief and he's waiting for the response brief from Social Security. And always, by the way, Joe, look for an opportunity. Sometimes they'll back down. Just say, can we agree to send this case back with these instructions? And, maybe you can work out a deal where you don't have to wait for a judge's decision. I see a lot of times, I do a lot of work with Carl Osterhout, Brian Konoski, who are appellate specialists, and they do a lot of district court work, which I don't do because I just don't have the time or the just really the staffing to do it. And many times I look at the paperwork, because I'm local counsel for Carl here in Georgia, or at least in the northern part of Georgia, and I see where the Social Security has agreed to a voluntary remand, because either they felt like their chances of winning were not great, or, and Carl's usually pretty selective and he's very smart and very good at what he does, but never foreclose the possibility you could work out a deal. So, keep that option open, Joe. I think that you may be surprised where, you may be able to work something out, because the U.S. attorneys that deal with this are really busy too. And quite honestly, winning a Social Security case is not a huge notch in their belt. They'd much rather win a big criminal or civil forfeiture case and a drug case than some, little Social Security matters. So they may be more open to making it go away just by sending it back to a judge, and save you a lot of hassles. So just keep that in mind. All right, Baxter has been here a number of years, or a number of weeks. Okay, so he's got since 2006. Okay, so 2023 date less insured, which means he's got to be proven disabled as of December 31 of 23. So the neuropsych evaluation in 26 is not going to be that probative or that important, because your date last insured is 23, unless it says this condition is long lasting. If it does address the fact this has been an ongoing long-term problem, then it could be help, and it certainly shows you've got an ongoing issue now. But as far as proving you became disabled before December of 23, a 2026 neuropsych probably won't help you that much. Now, if there had been a prior neuropsych that's very similar, you could argue that this just shows there's consistency there. You can find a way to use it, is my point, Baxter, but I don't know that it's going to be on its own particularly helpful, because it's 3 years after date less insured. Great, Patrick, I appreciate that. He says, thanks for all we do. He will refer people. I love that. I appreciate that very much. In fact, I'm going to put on here a here, if you're enjoying this, how to leave me a review. But that's very, very considerate of you. And look, I will talk to anybody. I have a staff. I've got a couple of call screeners. So if I can't get to them, we'll talk to anybody. We're not going to take every case. I'm not going to tell you I am. But we'll talk to everybody, and I try to give people, even if somebody I can't help, if I can give them a little bit of advice, I do that. We're trying to do a little more of that. It's just, I got to be careful, because I can't really offer advice. If I offer advice, I don't want somebody to come back later and say, well, I did or didn't do something because of your advice. I can offer general information, or where to look, is what I'll try to do. And again, the goal of this live stream and the videos is to help people know more about the process. But yeah, I believe in good karma. You put good stuff out in the universe and it comes back. But thank you, Patrick. I really appreciate that. Chloe says, what's the deadline most people underestimate the most, and what are the consequences of missing it? Well, I think clearly there are two I'm going to give you. One is the 60-day deadline for filing an appeal. It's 60 days, and they look at the date on the notice. And so let's say you get a notice that's dated March 13th, 2026. They assume 5 days for mailing, and you've got 60 days from that 5 days. So March 19th, I guess, would be, because they don't count the day of the letter, I don't think. So let's say March 19th plus 60 days would be, sometime in May, maybe not the 19th, but something like that. So what I would say is that, you have 60 days to file your appeal. Number one, that's not that long. And so, if you're going to get an attorney sooner rather than later. If you're running up to the deadline, get the thing filed within the 60 days. It's better to get it filed with almost nothing on there than to miss the deadline, if at all possible. Other thing is, realize that sometimes the date on the letter may be 2 or 3 weeks before you got it, because the mail gets lost, or they stuck it in an envelope and didn't mail it. So look at the date on the letter, the denial notice, and figure add 5 days to that, then plus 60. That's when you got to get your appeal filed. Third point is, when you do your appeal, if you're going to send it in by mail, give yourself time to mail. Do it return receipt requested. If you're going to do it by fax, then save the receipt. But the point is you're better off, in my opinion, if you get a denial notice and you haven't got an attorney, you want to get an attorney quickly. Get this done quickly. The attorney can file it electronically, and that will save you a lot of hassle right there. But my point is, get this all done very, very quickly. Don't wait till the last minute. If you are doing it yourself, again, it's better to get it in on time than to get it in perfectly 3 days late. Now, so that's one point. And by the way, if you are late on that particular issue, filing an appeal, you can ask for good cause, reason that you were late. You didn't get it on time, you're under medications, that you didn't concentrate, you didn't have transportation to get to the post office. You can come up with any kind of reason. And my experience is, even if you're as long as a month or even 2 months late, you can ask for good cause, and most of the time, in my experience, every time, within a couple of months, they'll give it to you. Once you get beyond 2 months, it starts to become a little more iffy. But I think as a rule, if you get it in within a couple of months of the deadline of, say, 120 days, you should be okay. But the better thing to do is don't go there, get it in within 60 days. So that's one big deadline, the 60-day deadline to appeal. And for goodness sakes, if you're angry because you get this denial notice, this form letter that just says, we've reviewed your file and we decided you can go back to your past work, and you're like, are they out of their freaking minds? I can't do it. And they get mad and you throw it away. Don't do that. It's much better just to appeal. This is not personal. There's nobody at Social Security saying, Big Ta, we don't like him. So we're going to go ahead and we're just going to screw with him. We're going to deny his case, even though we should approve it. That is not what's happening here. Okay, it's basically just a big inefficient system. So get the appeal filed on time. The second one I'll tell you about that I think people get really screwed up with is, if you get a notice of continuing disability review, not just the notice of the 454, 455, which is the forms to fill out, but they send you a letter saying, we reviewed your file, we think there's been medical improvement, we are now cutting you off. We are moving to terminate. You can appeal this. And you have 60 days to appeal that move to terminate. But you have 10 days, 10 days, TEN, to file a request to have benefits continue while you appeal. That can mean the difference of having money coming in to pay for food and shelter. So many people want to have benefits continue while they appeal the notice of termination. The downside to that, of course, or not of course, but I'll tell you, is that there'll be no past due benefits, which means you can't get an attorney in a contingency, but you will have money coming in. So you'll end up probably in most cases before a judge on your own, but you'll have had money coming in. Realize if you lose, you theoretically owe it back, but you could bankrupt on it. But that 10-day deadline is really quick, and so you got to move really fast, almost to the point I would tell you, physically go down to the Social Security office, walk in, hand it to them, get it stamped, get a copy stamped that prove that you filed it. So that's another really short deadline that you've got. But I think that the 60-day deadlines for initial and recon, I think at the Appeals Council, which you would file electronically, I don't think there's much leeway at all, by the way. I think this is requesting a initial or first a recon or maybe a hearing. You can get away with being a little bit late, maybe, but don't count on it. But at the Appeals Council level, no. So those are the two things I think that deadlines where they get really, really crazy or really, really hard line about. Kathy said she's in North Carolina, took 9 months, denial at initial and recon. So I'm not sure if you're saying that the whole thing took from start to finish 9 months. If that's the case, that's pretty good. That's pretty good. Bean Austin says, what determines if you get a short form versus a long form in the continuing reviews? I think that some of it's going to be determined by if the judge puts in the decision this case is to be reviewed in 12 months or 24 months or whatever, they're going to send you the long form. I think that if there is evidence that you've been working part-time, they'll probably send you the long form. Some of it may be random. I'm not aware of any resource that tells us for certain why they choose one or the other, but I think if they sense or believe there's medical improvement or there's evidence of work, they'll send you the long form, which is asking for more information. It's more like a reconsideration appeal. The short form is something I think they send out more randomly just to everybody, and it's computer graded, so if you answer no to all the questions, assuming that's correct, no work attempts, no significant improvement on the medical condition, and no doctor has said I'm doing better, things like that. They'll just basically say, okay, you're continue to be disabled. But the long form, somebody's going to look at it. And by the way, they just changed the process a few weeks ago where it used to be done locally. Now there's a national office that is doing these 454s and 455 reviews. So we have not yet seen whether this means there'll be more um, terminations or not. But it used to be done locally. Now it's being done in a centralized location. What that means, TBD. We don't know yet. 4 o'clock Lever, good evening. Hey, Christy. When I was waiting to go to hearing, I wrote a letter to update them on my conditioner in the time and got them to move it. Not sure if, when you say move the hearing date, perhaps. Kathy, Christy, I'm sorry, could you tell me more about when you say you got them to move it? What did you get them to move? The hearing date or something else? Kathy Clayton, okay. So, all right, so after 9 months of initial recon, you requested a hearing, then it must have gotten the attorney advisor, looked at it and said, this is a perfect example where initial recon were basically, denied, but somebody looking at it with a brain, half a brain, I shouldn't say it that way because adjudicators do work hard, but a person looking at it with a little more critical eye said, hey, this person is clearly disabled. And again, I apologize to any adjudicators watching. I'm not denigrating what you do. I'm just saying that I know you're overworked and a lot of times your hands are tied to some degree. But obviously, a judge, attorney advisors looking at it or judges' assistants looking at it, and they're looking at it saying, we know the judge is going to approve this case. We know the judge. We know, what he or she, how they typically approach it, and you meet the profile of a winning case. So I think that would be probably why you got approved, but congratulations on that. And of course the grid rules. And I think, Kathy is saying she was over 50, maybe over 55. The grid rules clearly applied. The only question, my guess, would be whether you had transferable skills. At the state agency, they don't like to get it. They don't really have the resources to get into that too much. So making a decision about transferable skills is sort of beyond the job description of an adjudicator. But at the hearing level, it's something that a judge is going to look at a little more closely. So what probably happened here was the attorney advisor went to the judge and says, we got a person limited to, I'm just going to assume you're over 55. Let's just assume that. She's 57 years old. She had past work as an SVP4 job, a semi-skilled job, but she's on oxycodone and hydrocodone and 5 or 6 other medications. It looks to me, Judge, that the grid rule would apply, that any skills you might have had are either industry specific or they are non-transferable because of non-exertional impairments. And the judge is like, yeah, that's what I would probably find. Let's go ahead and approve that one. That's my guess is what happened. And that's what I would do in a brief, by the way. I would argue the skills are industry specific or that the non-exertional impairments are going to limit any transferability of skills. Okay, so Baxter says his last day of SGA, which is substantial gainful activity, which is really any kind of work where you're earning, and again, it changes every year, but whatever the SGA was in 2018, if you were over that number, let's say it's $1,300 or $1,400, I don't remember what it was, then that's the last time you worked over SGA. Maybe you worked some part-time after that, but it was denied due to lack of medical evidence. Refiled in 22. Should I request the ALJ to consider it? Well, I mean, if you were denied before 22, I think a couple of things coming to mind is I don't think it's going to be reopened. It's going to be as your onset day with the day after your last unfavorable decision. And the real question in my mind is your date last insured, before, or when does your date last insured? Is it after? Is it still active? Well, you said it's, if last SGA was 2018, my guess is your date last insured would be 2023. You refiled in 22, you should be okay, which means that as long as you're found disabled before your date last insured, you are good for SSDI. The issue would be if you date last insured was in 2000, let's say 21, and let's say your date last insured is March 31 of 21, and your unfavorable decision was September 5th of 2021, then your new onset day would have to be September 6th of 21, which is after your date last insured. That's a problem. So as long as your date last insured is after the date of your unfavorable decision and your onset date, you should be okay. To at least to get into court. Doesn't mean you're going to win. It's going to mean you get into court. Okay, can I explain back pay and retro pay? Well, they're basically synonymous. It's the same thing. Let me get a sip of water here. And what it means is when you apply for benefits, let's just use some dates. Let's say that you applied in March of 2025 and you alleged an onset date of March of 2024. If you win, you can get paid 1 year prior to the date of your application, but there's a 5-month waiting period. So let's say, let's use March 1 because you don't use partial months, but let's say it's March 1. So you're eligible. You're found disabled March 1 of 24. You don't get paid for March, April, May, June, July. Your first payment is August of 2024. And so if you go to a hearing in August of 2026, you have 2 years of retroactive or past due payments. So that's how that works, is that you can get 1 year prior to your date of application, and you get paid your monthly payment amount for all those months that you've waited until you get a decision. So if it took 3 years to get to court, there may be 3 or 4 years of retro or back payments. So it's from the date of application, no more than 1 year prior to that date. And that's how back payments work. Patrick says medical evidence wins cases. I'd amend that medical and vocational evidence, because you don't win in a diagnosis. You need the doctor to talk about the functional issues that arose due to your medical problems. You got herniated discs. What does that mean in terms of lifting and carrying and standing and walking, things like that? Ideally, a statement from the judge, but it could be your testimony. But it's medical information as well as the vocational implications thereof. Okay. So Cynthia in Arizona says that she contacted both Senator Kelly and Gallego, and none of them helped, but she contacted a representative, and he did get things moving, or she did get things moving. So, my experience has been senators' offices are pretty good, but it may be a representative. But Cynthia's an example of someone who didn't give up, just, kept pushing. I need help here. You're my elected representative. Shame on the senators for not responding to you. Again, my experience has been that senators are usually pretty good about it, but again, everyone's different. Everyone's different. Okay. DWS says, I have a summary judgment hearing coming up in September on SSI, basically judgment proof. Is my disability SSI defense? Should I ignore the hearing? Anything else I can do to it? All right. And again, I don't want to get too much into civil matters, but in general, and you can look this up, look it up on Google. If you're an SSI, not SSD, I'm an SSI, a civil judgment against you by a credit card company or old apartment complex or vehicle lender on a deficiency claim, you are judgment proof that SSI cannot be garnished or seized. I'm not sure. I know that in SSDI cases, the government can go after it for student loans or past due taxes. I'm not sure anybody can go after SSI, but look that up. But I think that what I would do in this situation, and again, I think it depends on where you are. You might want to have a lawyer look at it. I would probably, talk to a lawyer about the advisability of sending a letter to the plaintiff's counsel saying, my only source of income is SSI. It cannot be garnished because of this particular code section. Cite the code section. Any attempt to, if you win your judgment, any attempt to garnish or levy or seize my SSI will go after you for violation of federal law and go after you for damages, you and your attorney. And that may very well make them go away. Now, they may say to you, we want a consent judgment that basically says that we recognize you're an SSI and we're not going to take any action, but should you return to the workforce, this is a judgment that can be enforced. You can say yay or nay. Again, I don't think that going into or having an SSI claim is a reason to stop the ongoing civil litigation, but it would certainly stop enforcement. I would also tell your bank, first of all, I would make sure that your SSI money is going into a very specific account that is called, DWS's SSI account. Do not commingle any other funds in there. If you're getting funds from any other source, don't commingle. Have a separate SSI account, and make sure the bank knows this is SSI money, and any judgment that comes down, do not honor that judgment. But I would probably be a little aggressive and just go after or at least reach out to the plaintiff's lawyer and say, you're good luck, you're wasting your time, but if you do get your judgment and you attempt to go after my money, I'm going to sue the pants off you because you're violating federal law. That's what I would do. Yeah, that's more of a debt collection issue, but yeah, look it up. Just type in federal law that prevents SSI funds from being seized by civil judgment creditor, and you'll find it. Okay. Marcus Wallace says, how does the SSI view someone who has major depression, anxiety, PTSD, migraines, and a brain tumor who is taking Depakote, which is an anti-seizure medication, 3 times a day, and Seroquel, and one other medicine? I would tell you this, Marcus, it is, you're giving me diagnoses. What does this mean in terms of your functioning? Now, I'm assuming that the Depakote and the Seroquel are going to have some side effects. And these conditions you're describing are going to have some functional, vocational issues. What that means, you're going to have to flesh it out. You're going to get doctors to tell you. You're going to have to, testify about that. So, as a starting point, I think it says to me, there are likely going to be vocational issues. Is it enough to put you over the top? That's the question. So I would really go into detail about all of that as far as what the functional issues are. Elise, I was talking about Elise before. This is Elise Enton, and we talked about attorney advisors, and she was an attorney advisor. And the question was, do judges routinely use attorney advisors? And Elise, who was one, says, unless the ALJ asks for review, are there less cases for writing decisions? Attorney advisors who write the case get it assigned after the hearing, and briefs are very helpful. ALJs usually review cases a few days before the day of the hearing. ALJs are going to be very limited number of hours to work on a case. So I said before that I thought that I had judges tell me they would look at it up to 2 weeks ahead. Elise, who was with Social Security up until a few months ago, says that's too generous. They're probably looking at it a few days, or even the morning of the hearing. And then attorney advisors are usually given the case after the hearing. Although, again, I think as we've seen by somebody, one of our commenters or visitors here said that an attorney advisor did look at the file and issued a decision. That may have been the judge looking at it and saying, here, attorney advisor, write this decision. So I think they can be active beforehand, but at least one of the points she made when she was on the live stream, we'll get her back in the near future. Her point was that everybody in Social Security, in the hearing office, the judges, the attorney advisors, the decision writers, are given less and less time to do their job. They have very strict time allotments to do what they're supposed to do, and so they have to kind of zoom through it. I was looking at a decision I got as an unfavorable decision, and it was a difficult case. I'll just leave it at that. And there's a bunch of notes in there. It looks like the judge scribbled some notes and somebody typed it up, and it's in there. It's just kind of like in the middle of it, all of a sudden you have all this sort of, shorthand. It makes no sense. It's not part of a written decision, but they were so quick, they were zooming through it so fast that they just left it in there. And it was a sloppy decision, and one of the things I think we would have grounds for appeal, the question being, is it worth doing this? But the judge makes a finding the claimant is limited to occasional fingering and handling. The hypothetical said frequent fingering and handling. Problem, because the judge made a finding but put a different limitation in the hypothetical, a less restrictive limitation in the hypothetical, that would be grounds for appeal. Now, the question is, are we, is there enough here that we're not rearranging deck chairs in the Titanic? That's the question. Is it worth it? I'm going to consult with a couple of people and see what they think, but I think it's clearly an appealable issue. Is it worth it going through the exercise there? But thanks, Elise, for chiming in on that. I appreciate that. So Marcus has a mass on the brain. Again, these are all things that logically could produce functional issues, but it's nice to have that all tied together by a doctor, that the seizures or the difficulty with focus or the problems with vision or hearing are tied to this, and these are not going to get better unless there's a surgical removal, or or they could lead to even more catastrophic results. But you got to get some functional issues in there, ideally from the doctor. Although again, if you testify about things that you're having and the type of issues you're having, let's say, seizures despite the Depakote, or problems with vision that are consistent with the location of the tumor, that could be enough to put you over the top. Better to have a doctor put it on record, though. Does working part-time, JC says, does working part-time under SGA, substantial gainful activity, which in 2026, $1,690 a month, count as past relevant work for CDR purposes? Or does work need to exceed SGA in order to count as past relevant work? My take would be it's got to be over SGA, because if it's under SGA, then by definition it's not past relevant work. It's not, work under SGA does not count as work. Theoretically you could work under SGA indefinitely, and that will not count as work. In fact, if you look at the denials at initial and recon, if somebody's working under SGA, they will specifically say that is not, SGA level work. So Social Security defines disability as being able to, do you have a medical problem that prevents you from engaging in SGA level work? Now, the issue in a CDR is, does the fact that you are doing under SGA work, is that evidence of capacity to possibly perform over SGA? Example, SGA in 2026 is $1,690 a month gross. What if you're working under SGA and you're earning $1,680 a month? Could they conclude that you're intentionally suppressing your income? They could. And if they say medical improvement and suspicious numbers here, that might be grounds for them to move to terminate. A judge might say otherwise, or a judge might say, how do you explain month after month that you're $10 below SGA? And realize SGA ain't a whole lot of money. We're talking $21,000 a year, round numbers. So it's not like you could live in Midtown Manhattan working at SGA level. But for their purposes, SGA means you have the capacity to work. If you're $800 or $900 a month, it's kind of hard to argue that means you could really do almost twice that. But, again, anytime there's my feeling is anytime there's part-time work, that muddies the waters a little bit, and it could come back to bite you. And I think Social Security has this balance in play, in that on one hand, they want to encourage people to try to work, which they should, and they've got all the trial work period, and the ticket to work and all this stuff. On the other hand, they don't want people playing the system and working, just under SGA and intentionally suppressing their income. However, if they start cutting people off for earning money under SGA, then what does being under SGA mean? I mean, you kind of get sort of this. It's a balancing act. And I think it's going to depend to some degree on the personality of the person looking at it. In theory, working under SGA should not cause you to lose your benefits. But like I said, if you're earning, again, here's a scenario. Let's say that I think SGA in 2025 was $1,610, $1,620 a month, something like that. Let's say in 2025 you earn $1,600 a month, and then just under SGA for that year. 2026 you earn $1,680, just under. It kind of looks like you're arranging your income to be just under SGA. Might that cause some suspicion? it's a pattern recognition. Yeah, it's going to be suspicious. So I think that would be just something to just keep in mind. Okay. Kelly asks, does SSA monitor or trigger a CDR if you travel outside the U.S. longer than 30 days if you're on SSDI? I have a diary awarded at 57. I don't know. I don't know whether immigration or I guess it would be immigration, or the customs agency, has a computer interaction with Social Security where it flags people who are on disability to see how long they're out of the country. I just don't know. I would doubt that. Is that something that could happen in the future? Clearly, it's a computer technology that would exist. But does being outside the U.S. mean you are not disabled? I don't think that you can draw that conclusion. Could it trigger somebody to ask some questions? Yeah, but I don't think that right now, to my knowledge, there's no computer link hotline between customs and Social Security that would trigger that. If they found out about it, that might be something they would ask questions about, as a judge would. I mean, if I'm representing somebody in a disability case, and the judge happens to ask, have you traveled any place, more than 10 miles out of your home, where you live in the last year, and you say, well, I went to France for 3 weeks, the judge is going to say, what were you doing in France? Now, I had that happen a couple of times, and the answer was, my family is from France. We went there to visit my elderly mother. I stayed in my mother's house. It took me a week to recover from the flight. I had to wear compression stockings from the flight. It was very uncomfortable. I had a wheelchair getting it out of the airport. When I got there, I was in bed for a week, but I wanted to see my mother because she's elderly. That is probably not going to be an issue. Going sightseeing and going climbing a mountain, yeah, that's a problem. So, which is another reason, by the way, why I would tell you, put your Facebook and your Instagram and your TikTok, put it on private. Pictures can sometimes be misleading. And certainly you shouldn't, if you're claiming you got a back problem and you're climbing a mountain, that's a whole other issue there. That seems to go to, against what you say your limitations might be. But you don't want a picture of a 10-year-old climb of a mountain be misinterpreted by somebody. But I don't think going out of the country inherently is a problem. It's just you might be asked what you did. Jam G. I'm working as a caregiver 1.5 hours a day, taking care of my mother, working way below SGA. Is this going to hurt my recon SSDI claim? Any advice we can? Again, I don't think if you're under SGA and you're helping your mom, I just think I don't think that's a problem. I think what I would tell you to do, though, is write down specifically everything you do, how much you have to lift, how independent or dependent she is, what happens if there's an emergency. Be prepared to explain exactly what you do and how far your responsibilities go. I mean, caregiver is not the same as a sitter. If you've got to deal with bathing and toileting and moving on and off a bed to a wheelchair, you might be lifting 150 or 200 pounds of dead weight. That's an issue. Because even if you're saying it's under SGA, the fact that you could do that with your mother or any other person, you could lift 100, 200 pounds, 2-3 times a day, and you're claiming back injury that you can't lift, you can't stand and walk, you can't lift anything, that's a bit of a problem. So I think I would really sketch out very clearly what you do, and ideally maybe have a lawyer take a look at it. Steve, I got an email from SSA, so my file was sent to Federal Quality Review. Should be concerned. My CE was, from what I can tell, favorable. And how does it affect my case if you go to recon or goes to a hearing? All right, so, and I think Elise, you may have talked about this when you were on. Quality review is where Social Security at the administrative level, I guess at the hearing level too, but administrative level, certain decisions are sent to another office to review, was it done correctly? My understanding, and I could be wrong about this, is some of it's random and some of it's based on, an algorithm they've got where certain cases, perhaps certain adjudicators, are decisions are being called into question. Um, you know, in my experience, most of the time it goes to quality review, it comes back, and the decision of the adjudicator is affirmed, whatever that might be. Um, a not insignificant, but not a huge number of times, maybe 25%, quality review changes for the worse, changes an approval to a denial, says the adjudicator was too generous. Every once in a while you see quality review changing a denial to an approval. More likely it's going to be the other way around. They'll see an approval by an adjudicator and they'll change it. So, this is just part of the process. Hopefully it's just a random thing and it won't make any difference. If for some reason they took an approval and changed it to a denial and you go to recon, to my knowledge, it will have no impact whatsoever on the recon appeal. It doesn't change the odds of getting approved or denied at recon or at a hearing. It is not a black mark against you because quality review changed. If anything, the argument I would make is that the initial thought by the adjudicator was this person's disabled, quality review changed it, but that doesn't change the fact that you were, in fact, approved by an adjudicator. So I don't think it means that there's any fraud or there's anything there. This isn't the part of Social Security after all. I just think it just means that somebody looked at it and changed their mind, but it doesn't negatively impact you going down the road if need be. Okay. Vinny Boy. The appeals council remanded the judge to redo the hearing because the judge never considered the consultative report or IME report, appealing the onset date. Any experience with this? It's going to be very completely fact dependent. If you're calling it IME, I'm calling it a consultative report. What's truly favorable to you, then the judge will have to give it whatever weight the judge wants to give it. But again, some judges, my experience, I'm speaking from my experience alone, some judges, if they get a remand from the appeals council or district court, they'll look at it and say, you know what, the appeals council district court doesn't do these for their health. They're probably telling me that I should have approved this case, or I should have done this a little bit differently. And sometimes a judge will pick up on that, depending on the wording of the remand, and say, okay, they did this. They're technically telling me I made a mistake in this area here, but they're also implying that I need to really give this a very close look because it very well may change the decision. Hint, hint, approve this case, judge. Some judges pick up on that. Other judges I don't give a blankety blank what the appeals council or district court says. I'm going to do whatever I want. Depends on the judge. So I think in this case, it depends on what your CE report said. It depends on the judge. It depends on the wording of the remand order. Before I could tell you, the underlying merits of the case, before I can't really offer an opinion as to what that means. Pricey Joy. Don't worry too much when they mention the Postal Service. They seem to do that for everyone. Mentioned during my hearing, it's still one. It's never an actual win to be disabled. You're right on that. Postal Service. I'm not sure what price Pricey Joy is getting at, but certainly the Postal Service. Well, I will tell you this: that the job described in the DOT, if you look at postal work in the DOT, is described as a light job. But if you look at job postings from the Postal Service, it's a medium job. This is an example of the DOT. And I think the VE even said that wasn't updated, last updated in the 1970s. And his point was, to his credit, he said, 1970, we didn't have, Amazon packages. We didn't have all this, mail delivery, Walmart Plus. It was mostly letters. Now it's a lot more packages. So it's an example of a job where the DOT description is totally obsolete and incorrect. And so this is where, under this 24.3p, a judge would ask a vocational witness to come up with a better thing than the DOT to describe how that job worked. In fact, this VE even said, well, I was at the post office last week and I know these people lift 50 or 60 pounds. That's not, to me, that's not a particularly compelling statement. I think it's better to say, I've looked at job postings from the Postal Service. I've placed 15 of these people in the last 5 years, and this is what they got to be able to do. He did acknowledge it was not a light job, but he didn't go quite as far as I wanted him to go. ENS says, evening, everybody. Good evening to you. Everything is coming down to your ability to work. Yep. Keep your eye on that, not your list of symptoms. You're absolutely correct. It comes down to work capacity. Again, Social Security's definition of disability. Do you have a medically determinable condition or conditions, so the diagnosed problem, with some treatment, that has lasted or expected to last 12 consecutive months, the duration requirement that prevents you from engaging in SGA or substantial gainful activity? It's all about work capacity. So the diagnosis is important because it's got to be medically determinable. It can't be, it's really hard to win if you have this sort of undifferentiated pain syndrome and they don't know why it's happening. It could be you get past the, medically determinable part if you have a doctor treating you saying, we know there's something there, we just don't know what it is. But much better to have a diagnosis. But the diagnosis alone gets you past step 2 of the sequential evaluation process, but it doesn't get to not being able to work or do substantial gainful activity. Honestly, an attorney should be paid. Hey, you're speaking to the choir, Cynthia. I appreciate that. Navigating the system is nerve-wracking. I'm thankful that, okay, well, I'm glad to have you as our client. And yeah, you know what? We earn our fees. I mean, there are, I would tell you this, in my 35 plus years of experience, there are far more people who get denied who should be approved than the other way around. And statistically, people that go through this process without an attorney, substantially less likely to get approved. And that's not because, what we do is, the most sophisticated law available. It's not. But you get into the disability system, you got short deadlines, 60 days, 10 days. You got a lot of acronyms, DLI, AOD, SGA, PRW, UWA, all these acronyms out there. You're in a different universe. You get in front of a judge, you got 45, 50 minutes to prove your case. Judge isn't going to explain everything to you. He or she expects you to know. And, you can't produce, you didn't know that you're supposed to keep the evidence updated after you requested a hearing. The last evidence in your file is a year and a half old or a year old. Judge is going to say, you know what, you didn't get the 5-day letter in. I'm going to look at this case. There's no evidence in the last year. You're out. I mean, it can get brutal. You can, ignorance of the law is not an excuse. So, just knowing how the system works is important. And, there's the old saying that he who represents himself has a fool for a lawyer. And I will tell you, having been involved in legal matters personally, whether it's lawsuits or not that many lawsuits, but, real estate closings, but I've been sued before, bogus lawsuit, but I've been sued before. And you know what I did is I went and hired a lawyer because that was not my area. And I was, I was pissed off because it was stupid. I had to get a lawyer. We got it, made it go away. It cost me some money, yes, but you know what? It was the right thing to do. I go to a real estate closing. I don't know closing law. I don't know, making sure that the deed is done correctly. Paying a lawyer. It's just, unfortunately, the system is complicated enough where, sometimes you got to have a lawyer. And this is one of those areas, I think. It's just, I wouldn't do it on your own. Doing an initial recon, sure. Go to a hearing, don't do it. I'm just telling you, it's not worth it. But I appreciate the kind words, Cynthia. Are you learning? I'm trying to learn, are you? I always trying to learn new stuff. Okay. 100% VA, permanent and total disabled vet, 46 years old, and thank you for your service. Severe PTSD, major depression, 100% able to work due to symptoms, multiple attempts at work, but firings, terminations, unemployed, seeing doctor, would you take the case? Those are tough cases. I will tell you, this is a situation where PTSD, major depression, what I look for, quite frankly, is, I think one of the things you've shown here, The firings and terminations, that represents a history of problems trying to get to work. That is a relevant factor. The factors I'm looking at would be, have there been, and I'll just flat out tell you what I look for. Have there been suicide attempts? Have there been inpatient hospitalizations? Have there been multiple medication trials, things that have not worked? These are the sort of things, the firings and terminations, those are important factors. But in my experience, at 46, you're under 50, you've got to show that you cannot do anything. And literally that means if I said to you, here is a job, you're sitting at a table and you're putting back scratchers. This is a back scratcher, if you can see it here. Back scratchers in a box. Okay, these are a few ounces. All day long. You're in your warehouse by yourself. You can sit or stand as you need to. No interaction with anybody else. No interaction with coworkers or supervisors. There's no, it's a controlled environment. And all you have to do is show up and fog a mirror and just put this in a box. Minimum wage, you'd be bored out of your mind. You couldn't make ends meet. Could you do that? And do you have evidence to say you couldn't do that? Now if you took a job that required you to be, interacting with customers, different, that maybe you couldn't do that. You had a job that required you to report to a supervisor every 3 hours. Let's say you couldn't do that. But here's a job where it's basically doing one task and you check with your supervisor once every week. Could you do it? And more importantly, is there evidence to say you couldn't? Are you taking medications that put you to sleep? Have you had situations where you tried a job like that and you had to leave the work site because it was too stressful for you? Would fluorescent lights be a problem for you? Do you have flashbacks no matter what you do? Do you have seasonal affective disorder where in the wintertime you might be in bed for a week or 2 weeks between, October and February or something like that? Have you been institutionalized for suicide attempts or major depressive disorder? I mean, it's got to be at a really, really, really high level. So that's how I would answer that question. Leland, what if I can sit, stand, and walk for 6 hours one day, but it causes you to miss the next day or two? Well, again, if the medical evidence says, you could do that, one day, that's not meaning you could do it ongoing. So if you can get a doctor to say that you would need, after doing any type of activity that required standing, walking, lifting 10 pounds or whatever, but that you would need a day to recover, and you could maybe get through 3 or 4 days of work a week rather, because of the need to recover for a full day after even minimal physical activity, that would be a disabling level of impairment. That's a hard thing to get, but that's what you would need. And of course, underlying evidence to explain, are there herniated discs, are there, back or knee or whatever the body part is that are consistent with a level of impairment like that. Pricey Joyce says employers can be so short-sighted. Official retirement is until 67 now, for one thing. We don't want the boss's job. We've been there, done that. And I think what Pricey Joy is getting at is, I made the point earlier that many, many times people, and I was talking to my client, over 55 are having a hard time finding a job because of ageism. Employers don't want to deal with an older person. Why? Because they're more likely to have a medical problem. They're more likely to be more difficult to train. Any number of reasons. They're probably going to leave in a couple of years. Is it short-sighted? Sure. But, depending on the state you live, most states do not require employers to hire somebody. Georgia, for example, is basically you can be fired or hired for any reason as long as it's not illegal. So if you walk into a job interview and the potential employer doesn't like your haircut or doesn't like your glasses, they can say, I'm not going to hire you. Now, the real reason may be because you are 57 years old, or because you have braids in your hair, because you're African American. That may be the real reason, but if they don't tell you that, if you don't know that, and you can't prove it, then that's you're not going to get that job. There's nothing much you can do. Now, of course, you could go to the EEOC and try to show a pattern, but again, that's a whole different area of law, a whole different ballgame. But my point is that being hired and fired in many states is simply they want to fire you. You walk in one day, you're fired. I have a close relative of mine who, was doing a great job at the work they were doing, and a new CEO comes in, you're fired. And this person was fired. Fortunately, kind of saw it coming, but they're fired, and nothing you can really do about it. So, yeah, it's not fair, but it is what it is. Joan Haig, or Higgy. Hey, Joan Higgy. You say SSA didn't care. I mean, they're just a big bureaucracy. It's not like there's anybody there who's sitting there going, let's figure out a way to really stick it to a little pricey joint. No, not that. It's just that, they're doing their job. And adjudicators are like insurance adjusters. They probably get a little jaded, a little cynical about all these people that are applying for disability. Many of them, and if you remember, I had a person on, I think she went by Linda, as a former adjudicator. I'll see if I can get her back on. She's now at a private insurance company. She's like, we want to do a good job. We want to get people who are truly disabled on benefits, but they've got a lot of hoops to jump through. Good night, Ricky. In fact, we're down to about 10 minutes, so I'll be going, as you can well see, I need my beauty sleep. I got a haircut tomorrow, by the way. You notice I've been my hair keeps sticking up. I'm going to get a haircut tomorrow, so I look a little more respectable next week. What do you do if none of your doctors will fill out an RFC, or residual functional capacity form? I call them FCE reports. A lot of doctors won't do it. You just have to, get the objective evidence, the MRI reports, the CT scans, and testify very clearly about the limitations and make the argument that the limitations are consistent with the testimony. And even though there's no FCE form, these functional issues do arise. I think judges are not expecting to see them because insurance, dictates a lot of medical medical care, and a lot of doctors won't do it because they don't get paid for it, and so judges know that. Do you want to drive by? Jonathan, good to see you. Get my Medicare October 1 this year. Thank you for what you do. Sure. Not sure what the drive-by is, but I'm glad you get your Medicare, and I appreciate your kind words. Demand request your records for sure. And by the way, what I suggest people do is if I'm representing them, I get their records as it's a download, or it's online. I can download them. I will send anybody who wants, my clients, a PDF of their entire file. They have all their records for several years, and that's a good thing to keep. You should always keep your records. What's the quickest I've seen from initial filing to ALJ? Has always run 3 years. No, I mean, I've had a couple that have been approved within 4 or 5 months. I had one, I've told this story before, a fellow that I grew up with, known him my whole life, and unfortunately he developed lung cancer. He was a smoker, developed lung cancer, and he called me up and he was trying to work, and I kept saying, at some point, when you stop working, let me know. We'll get this thing moved through quickly. But to his credit, he wanted to work. He kept trying to work. Finally, one day he called me. He's like, I just can't do it anymore. What I do is I went to the listing because it was a listing level case for lung cancer. I got a statement on the listing. I sent it to him. I said, take this to your oncologist. I added some questions to it about, is it going to last a year? Is it like, is he going to be able to go back to work? Blah, blah, blah. No. He meets the listing. Filed the application, submitted that with the application. I think I got him approved within 2.5, 3 months. So he did get, and of course in fact, I got him approved. I think I did get maybe a little bit of money on that one. It wasn't for the money, because I wouldn't expect to get paid anything. So it must have maybe 6 or 7 months because I got a few $100s for it. But he got approved, within, after the 5-month waiting period. I think there was 2 months, so it must have been 7 months. And he got approved and he got benefits, and unfortunately he passed away a few months after that, but we did get him on, so at least he had a few months of benefits, and he left for his wife. So that's about as fast as I got. I've seen him. And I've seen other people tell me they've seen a few that quick, but I'd say 6 or 7, 5 or 6 or 7 months is pretty quick. Afsana, you got a different handle now on your, because normally you have a different name on your, but good to see you here. How are you doing? Baseball dude, and we don't have a decision yet, by the way, Afsana. I just always look. I'm looking for your case to see if we can get a decision. Let's check again. Nope, nothing there. But it should be coming soon, and I think it'll be an approval. Um, People doing a drive-by. Oh, you're doing a drive-by. I got you. Okay. You're just kind of popping by. Well, I appreciate you stopping in. Baseball dude, thank you very much. Um, all right. Pricey joy people. Well, bench decisions, that's when a judge decides the case without a hearing. Those are great. I love them. It makes everybody's life a lot easier, a lot less stressful. Hal Clayton. Good evening. Hope everyone's doing well. Struggle is real. Swear to God, y'all, why in the name they make this stuff so common? I don't know, Hal. That's a good question. I mean, you know, I'll tell you, I've been a lawyer for a long time, and I did, before this, I did bankruptcy work for a lot of years, and I started doing this as well. I've done some workers' comp, little litigation, PI litigation, done a few other things over the years. It's all complicated. I just think that, you know, our system, realize lawyers designed it. You know, most legislatures, you know, Congress people, whether it's state or federal level, they're lawyers. There's a lot of special interest putting stuff in and, you know, putting their fingers on the pie to get special considerations. It just gets complicated. It shouldn't be. It shouldn't be, but it is. But again, you think about it, you know, disability. You know, why do you get paid for this? Because you can't work. But what does that mean? You know, no, so they don't want to say you can't work because work is not the issue. It's substantial gainful activity. What is substantial? You got to come up with a definition for that. What is activity? Is it passive? Is it act? You know, I mean, you know, that's what lawyers do. They argue about words, and every word has a specific meaning. And you know, realize the legislature drafts the statutes, and there a lot of times it's a compromise between, you know, Republicans and Democrats and lobbyists are involved in it as well. A lot of times the statutes are not drafted particularly well. And so you take it to the courts where lawyers fight over what did the legislature mean. And it's not like the legislature is a person. So, you know, what is a reasonable explanation of what we think the legislature intended? Well, that was the legislature 5 years ago or 15 years ago. Is it what the legislature thinks now? You know, is it what we think? I mean, you can start to see it just starts opening up for a lot of different interpretations, and that's what lawyers do. We fight over meaning of words. We fight over what this should mean, and you know, in disability, look, I've had cases where I know Judge A would approve it and Judge B denied it. You know, just because Judge B has a different approach to what it means to be disabled. That's just what lawyers do. Bestie something lady, 5251. Greetings. You're welcome. Good to see you. You got to really, Pricey Joy's right. You got to prove it all. All right, let's kind of zoom through a couple more. Spousal benefits. You know, I don't want to answer this because I don't really deal with retirement issues, Tommy. I'm not the right person to ask about this. And I would defer to somebody who deals with retirement Social Security. I just don't deal with that. Hawk asks, how would I proffer my own hypos in a case? What's irrational? Yeah, I mean, I would, to answer that this way, I will almost always set a hypothetical out. I'm always, if the judge doesn't do it, I'm always going to put one about you know, missed days from work or percentage off task if the judge doesn't do it, because you got to put that in there just to cover things. I may, if let's say there was a question about the person's, let's say, handling and fingering, and I've got evidence they've got trigger finger or carpal tunnel, and the judge's hypo asked for frequent handling and fingering, and I'm going to say occasional, and ask for a different answer. And then I may say, what about, you know, minimal? Or I forget if I'm not sure if that's the word I use, but let's just say less than occasional. That would be infrequent, you know, maybe 5 times in the whole course of a day, and see what comes back. Now, what judges will do is they'll jump in and say, okay, well, let me change this and ask it this and blah, blah, blah. You know, ultimately, the hypothetical that's going to win or lose your case is coming from the judge. I can pose my hypotheticals for preparing my case for appeal, saying I ask this hypothetical and I can argue an appeal if the hypothetical I set out is more reflective of the person's medical record, and that the appeals counsel or district court should instruct the judge to use that hypothetical. That's why I would put it out there. But it's usually because it's not because I'm going after the VE. It's usually because the judge, I think, didn't put everything in there that should have been in there. And so I'm trying to show that the judge did not include all the impairments in there to preserve the record for appeal. Because if I'm having to, pose a complicated hypothetical, it's usually because the judge didn't, and that's not a good thing. Like the judge only asked one question, and it said you could do past relevant work, and I said, well, let me ask you this, and I get rid of, and I'll go through the whole thing, get rid of past relevant work, get rid of all work. I may ask 5 hypotheticals. It doesn't matter if the judge is going to rely on the one he came up with. Melissa Smith had a hearing with Dutton. Again, that's Judge Dutton 2 years ago. She's very tough. She inquired about guardianship of grandson and circumstances. What's it with the ability to work? What does that do with my ability to work? Well, the issue is if you're guardian of your grandchildren, that's responsibility, number one. What are you doing? Are you helping with homework? Are you scheduling? Are you taking your grandson to school, to activities? That kind of looks like could be a job. I mean, being a parent is a tough job. I mean, I've got grandchildren now, and on Wednesdays, I don't work on Wednesdays. I mean, I shouldn't say I work between dealing with the children. I work in the morning, I work at night, but I don't work when I'm taking care of them. It's a lot of work. So if you're careful, if let's say you have a grandson who's 15 years old and he can make his own breakfast, make his own lunch, he goes to school, comes back, you just say, hey, Junior, have you done your homework? Yeah, leave me alone. He goes to his room and does his homework and then gets on Xbox. Okay, that's not really like a job. If you've got a 4-year-old, a 3-year-old who you've got to, take to school and to help with homework and to teach to this and to take him to soccer practice, and that's a whole different ballgame. That's why, because your activities of daily living could seem like substantial gainful activity. SGA is not just work with earnings. It can be other activities as well. Okay. All right, I'm going to take one more question because we're already at 2 hours, and I invite you all to come back next week. Mato 7, 44-year-old in Georgia. I have severe scoliosis, lordosis, spondylitis, whole back fusion, 4 back surgeries, tricompartmental osteoarthritis in right knee, type 2 diabetes, ALJ hearing on August 24th. Thoughts? Well, I mean, you've got significant medical issues. And again, those medical issues logically would result or produce functional issues. Obviously, if the doctor would say that you need to take unscheduled rest breaks for 45 minutes 3 times a day, that's better than you saying it. Okay. Are you on narcotic pain medication? If so, what are the side effects of that? All these issues are significant, but again, you don't want in the diagnosis, but I think it's reasonable to think that functional limitations would arise. If you were 54 or 58, I'd say your case is really, really strong. 44, you got to prove you cannot do any job at all, which means that even a simple job, sit-stand option in that warehouse, putting, back scratchers in a box, you couldn't do. If you get medical support to say that you would be, take too many days off, that you're going to have to rest during the day, unscheduled breaks for, 3 times a day for 30 minutes at a time. You can only be on your feet. You can stand for 3 hours, sit for 2 hours. That's 5 hours, not 8 hours total. Then I think you win. I think it's just a matter of, how significant are those problems vocationally? That's how I would answer that question. I wish you the best of luck. You didn't tell me who the judge was, and that would also tell me something as well, because some judges are going to be, and I see Hawk says you might need a listing. You might, although I would tell you that if you're at a hearing, the musculoskeletal listing is really, really hard to meet, so I wouldn't assume that. It's probably going to be a functional capacity assessment. If there's a medical expert there, the medical expert could say you meet or equal a listing. True. I don't think it's very likely, but it's possible. But who's the judge? That could also make a difference as well. So, okay, I got a bunch more questions, but folks, I'm at 2 hours, and what we will do is reconvene next week, same bat time, same bat channel. I hope this was useful to all of you. I hope you enjoyed it. I hope you all have a great weekend, safe weekend. Stay cool. If your kids are going back to school, I hope they're safe as well. And we will do this again next week. So I hope everybody has a good one, and I'll see you next week. Thanks a lot.